We go. All right. Good morning again, everyone. I was just getting the system set up. Apparently, one side or the other shared the Zoom link with lots of people, which is okay so far. There's also a live feed of what we're doing through YouTube. I don't mind all these folks on here as long as it stays quiet. If people start chiming in, then I'll have to send everyone out of the Zoom session, and then they can just watch along through the YouTube feed off of the Superior Court's website. But it's an open proceeding, and it's fine for anyone and everyone to be listening and watching. But I'll be hearing from the lawyers and their clients and not from other folks. So, Madam Court Reporter, it looks like you're ready. I see things flying along. We'll get on the record. This is 25CV003074. Mr. Libby, how do you pronounce your client's last name?
It's Bhaumik.
Bhaumik. This is Bhaumik versus the Bengali Association of Greater Atlanta and Mr. Carr. Mr. Libby represents petitioner, and who do we have for the two defendants?
Your Honor, my name is Scott Ratchick. I'm counsel for both of the defendants. We have filed a motion to dismiss on Friday, correct? We have not yet answered, which I guess that'll happen this week. Our deadline to answer is still pending.
Okay.
So we will do that this week. I know that we just filed that on Friday. I didn't really get a chance to speak with Mr. Libby about it yet.
Well, we're all going to talk about it this morning, and if he needs more time to respond, he can. It seems like Section 18.3 of the bylaws resolves that, and I suspect Mr. Libby's going to want me to follow the bylaws in addressing some of his concerns. So hopefully people aren't picking and choosing the bylaws they like and ignoring the rest of them, like other things going on in this country right now, but we'll see.
So far, you haven't said a thing I disagree with.
Okay. Well, let me frame what I understand the issues to be, and that may be too bold a statement because I don't know that I'll do all of that, but at least what we're going to cover today. So Mr. Bhaumik has sued the association. I'm going to call it the association for shorthand, but by that I always mean the Bengali Association of Greater Atlanta. He sued the association and Mr. Carr, who I believe is a member of the board of directors, challenging some steps that were taken and maybe some steps that haven't been taken, all of which he contends are part of the bylaws of the association concerning how the board of directors is composed, how people are elected, when they should be elected, and what ought to happen when. Hold on one second. Membership of the board of directors drops below 5. That seems to be a magic threshold according to the bylaws. And when there are fewer than 5 directors, then there needs to be a special election to get the group back up to 5. There have been a few resignations. Some of the resignations are of directors whose terms don't run until 1 year from today. And one resignation of Director Roy, that term ends today. I don't know, but you all will educate me, I'm sure, if there are other directors whose terms end today such that they're on what should be the ballot tomorrow. We're working with some compressed timeframes because it sounds like maybe there is supposed to be an election tomorrow. Certainly, Director Roy's term ends today. And so Director Roy, unless there's you can carry over until the election is scheduled because the first is on a Sunday or a holiday. There may be a provision like that in the bylaws, but we are working with a depleted board, and Mr. Bhaumik believes in his petition, I think, could we just do it by the books? And he may not be interpreting the books correctly. We may need to have a back and forth about that, but this is not about, at the surface and what's before me, malfeasance, or the board is taking members' funds and spending them the wrong way, or it's taking this organization in a political direction when it should have a cultural focus, or anything like that, which is good. I'd prefer to keep it that way. It strikes me right now as these are the rules in the bylaws as to how we populate the board of directors, and Mr. Bhaumik is saying, could we please do it by the book? I think that's sort of where we are. Mr. Libby, you had asked not only to handle the motion for emergency temporary relief, but let's just deal with everything today, which may be necessary if the election is tomorrow. Not a lot of good reasons to say, let's meet in a month to talk about then an election that's already happened. Easier to try to do things before the election rather than after. And we also have pending this motion to dismiss, which isn't ripe, but it does seem like Mr. Carr is welcome to be here, but ought not necessarily to be here officially as a respondent. And so I guess what I'd like to start with, Mr. Libby, is your initial reactions to the motion to dismiss Mr. Carr, and then we'll get to the main event.
Thank you, Your Honor. Yes, my initial reaction was that I didn't even realize that provision was in the bylaws. I had not gone that far down into it. I mean, I think I've seen that page before, but didn't realize there was a provision that said none of the officers can be sued at all. My first instinct on that is to say, wow, that's a pretty powerful provision in this case. Figured it could use some interpretation. I understand, obviously, the position of opposing counsel on this, on Mr. Ratchick's position on this. I would like the opportunity to do a little more research. I didn't really have that. But at the end of the day, I don't know how. I think maybe if we can put that on hold until the end of this hearing, it might get resolved through the course of the court.
Okay. Are the bylaws attached to the petition?
They are.
All right. I'm going to get them up so I can see them. Mr. Ratchick, I'm okay with that response from Mr. Libby. You were very upfront about the fact that your motion to dismiss just landed. And so I wasn't expecting Mr. Libby to be able to cite chapter and verse the case law that he thinks overcomes the challenge. I'll just repeat that if 18.3 or whatever it is says what it says, powerful or not, it's a provision of the bylaws. And it doesn't seem to be an unconscionable provision. You have to give your left arm if you are terminated early from the board of directors or something like that. But I appreciate Mr. Libby saying, I'd just like a little time to process it, and it may be moot by the end of this morning.
I have absolutely no objection to that. We obviously did just file it on Friday. I understand that. And hopefully we will resolve it through the course of today. Your Honor, would it help you, because I see you looking for the bylaws and stuff like that. I actually printed out copies of them. Would having that in physical form for you?
Let's see. Right now, I'm good. I have 18.3 in front of me. No BAGA officials can be sued for any reason whatsoever. Full stop. Not a lot to interpret there.
There isn't. I know that we're going to get to section or Article 5, but if you want it, I have copies.
Thank you. I will keep that in mind, and if I'm having to bounce back and forth between screens too much, then I'll say, let's get a paper copy.
And I also brought paper copies of the petition because we may be going back and forth. And I know for me, when I was looking at it, the petition had all of the documents behind it as exhibits, and it was, you know, less easy to scroll back and forth if I had them side by side.
Okay.
So if you want them, I've got them.
Thank you.
Your Honor, I provided all of the exhibits that we would intend to use today as separate documents to your, I think it's Ms. Niles.
Ms. Niles, the staff attorney.
Yes, so I think they should be available, and I was intending to bring them up on Dropbox and to try and do it, I guess, digitally.
Okay.
I mean, not Dropbox, Zoom.
Great. I mean, if your screen is on,
Yeah.
you actually can't share through that. You'd share through your own device.
Yeah.
Great.
Oh, yeah, I'm fine that's right. I don't need that screen then.
Yeah.
Okay.
In case if you want to have copies of some of the exhibits, if you want to use them.
Okay, sure. I've got a hard copy just for any witnesses to use, but I figured,
Fair enough.
yeah.
Okay, then let's turn to the main issue, which is the challenge raised in the petition Mr. Bhaumik brought. And Mr. Libby, I did my best to summarize. There are a lot of moving parts, but do you want to add more? I don't need opening statements from either side, but what I do like to be told, very frankly, is Judge, actually, it's the wrong case. This isn't we're here suing because it involves fraud and waste or whatever. I know I don't have the wrong case, but I want to make sure I'm focused on what your client's concerns are.
Sure. Thank you, Your Honor. Yes, just briefly, this case is really primarily about what the correct process is in holding an election for directors to the board of directors for the Bengali Association of Greater Atlanta. At this point in time, I believe Mr. Carr is the chairman, at least today's his last day, but as of today, he's the chairman of the board. There are currently three other directors who were elected, and one that I understand is a director by appointment at this time, but his term, I think, also may expire. Yeah, it expires today. So all new directors who would have been voted onto the board had the election been done properly would begin their terms tomorrow.
Would begin their terms tomorrow. Oh, because there already was an election.
And I'll explain the election process next.
Okay.
The election process is actually, there's a nomination process first. And under the nomination process, what happens is the board sends out an email to the membership of BAGA generally, and BAGA is the Bengali Association, and saying we're calling for nominations of anybody who essentially wants to nominate themselves to the board, or if anybody wants to nominate anybody to the board. And what happens is the membership can fill out this form that was attached to the email saying we nominate this person, what have you. Once all the nominations are in, then there's an election committee, and the election committee for the board, this is my understanding of it, I may not have it all right because I'm not in the machinery, but the election committee then goes through the nominations, and if there are more than 5, in this instance, if there are more nominations than there are positions open, then there has to be an election. And if there's not enough nominations sufficient to fill all the positions, then all the nominees automatically rise up to the level of director. And then if there's a shortfall, I think if there has to be at least 5 members. So if there's a shortfall that makes it fall below 5 for any reason, there has to be a special election to have that 5th member appointed.
So this election board doesn't do any screening. They're literally counting and making sure, are there enough nominations to fill the board? If there are more than open spots, we have an election. If there are fewer than open spots, but we'll have at least 5 directors, okay,
Yeah.
we're all right. But if somehow we dip below 5, we have to have an election, or if we dip below, what is it, 3 and I guess it's 7. So if there were 3 openings and only 2 nominees, is there still
Yes, my understanding of this, and I believe Dr. Bhaumik's, is that if it goes below 7, that's okay. Because I think the issue is if you start with 7 at the beginning of a term and someone resigns, you don't have to have an election immediately. You can wait till the next term. But if it goes to the point of being below 5, a special election is necessary to fill that position. And, it's our position that if that election, does not happen, and this is under section 5.6 in the bylaws.
Okay, and we can dive into things later. I'm noticing that 5.5 says that the board is 5 to 7 directors. So it seems to me that if they were at 6, that's not cause to do anything at all because they're in that range of 5 to 7. They don't have to have 7. They can. I guess if enough people say, I want to serve, that you could get to 7, then you need to let those people serve. If an 8th raises his or her hand, then you have an election. The magic number is 5. And if there are fewer than 5, that triggers other things.
That's correct.
Okay, got it. All right.
So In this election, what has happened is
When was it?
The election, the original call for nominations was February 1st. At that point in time, 2 members of the board had resigned. Both of their terms ended next March 31st, so a year from now. And so there was on February 1st, an email was sent out, call for nominations by the board to the general membership. And then on February 13th, there was a second call for nominations because another member of the board had resigned on February 13th. And in that case, there was a call for 5 people to be elected to the board. In both of those calls, there was a nomination form that you fill out, which provided that whoever's being nominated is being nominated to fulfill full 2-year terms. However, there were 2 unfinished terms, and then there were 3 by the time February 13th came around, 3 full 2-year terms to be elected for.
Paul and Dar
Yes.
were the 2 who resigned. I'm gonna call it early. I mean, technically Roy resigned early, but it was a couple months early. But Paul and Dar are the 2 whose terms would have run through 1 year from today.
Yes.
And your contention through your client is that, and I'm assuming it's in the rules, the special election there is for the remainder of the term and not a full 2-year term. So if I ran for, I don't know if Paul is male or female, but Director Paul spot, really, I would only be running for 1 year. I could maybe re-up later on. But what happened on whatever date you're about to get to, because I interrupted your chronology, was that if I ran for Director Paul's spot, or I was appointed to it, I got full 2 years. And that's not consistent with the bylaws.
That's correct.
Okay.
Okay. And the same thing with Director Dar, who I believe resigned February 1st. And so when this election came around, if they wanted to fill, and then just so you know, today is the last day. This was 4 people left on the board as of today right now. 2 of those people roll off today, Mr. Carr and another member, and then 2 stay on because they have to fulfill their remaining 1 year of their terms.
All right, so that's helpful. So Mr. Carr's term expires today. Who else who's still on it? Nandi?
Nandi.
Yeah.
And
Carr.
Samater?
and Gupta.
Nandi and Gupta have 1 year left.
Yes.
Yeah, Nandi and Gupta have 1 year left. And then the last name you just said, I think, has.
SAMMADER.
They roll off today.
Which one?
SANNAD.
Sarbani.
Today.
Today. Okay. Oh, sorry, Your Honor.
That's all right. So when was the election?
So there was ultimately no election because there was a total of 5 nominations made. So all the positions were filled.
Oh,
So, and then what will happen tomorrow is that the 2 people who are on the board right now who have 1 year terms will finish their 1 year terms, presumably.
Nandi and Gupta.
And then 5 new directors will begin 2 year terms.
Okay, and is the lone concern of your client that 2 of those 5 really should only have 1 year terms, or is there more we need to unravel today?
That's the primary concern of my client, is that they should have 1 year terms each. So it should be 3 full terms for 3 directors and 2 directors going into 1 year terms.
It's not that, gosh, there were only 5 nominations and there are 5 spots, so there's no election.
Yes.
Okay.
Yeah, it's not a matter of, there's no issue with the fact that there was an election given there was only 5 nominations total. However, one of my concerns as my client is that the nomination process could have turned out different had people known there was 2 positions for only 1 year. It could have caused other members to come forward and say, I'd be willing to do 1 year. I've never done this, and that sounds good. It also people in the membership, our position is might have chosen differently for who they wanted to serve 2 years versus 1 year. That makes a difference in their voting rights.
When someone is nominated, are you simply nominated to be on the board, or are you nominated for, like, do they have districts or seats so that Director Dar is seat number 6? And I nominate Casey Libby for seat 6. I'd know I only have to deal with you for 1 year because there's only one. If things were done consistent with your client's interpretation of the bylaws, I know that I'm nominating you for a 1 year slot. Or how would they decide which 2 of the 5 are the 1 year ones versus the 3 year one, the 2 year ones?
So one thing that would happen is when you have nominations, the people who are being nominated would say, well, I want to go for the 1 year spot or the 2 year spot. So there would be a limited list of people up for each spot.
Okay.
And then that way, when you're picking the board position you're filling, you say, oh, I want this person. They're nominated for 1 year. Sure, I'll vote for them for 1 year, and I'll vote for them for 1 year. And the people who are nominated for the 2 year spot would be picked for the 2 year spot. So it would kind of play out that way automatically, because you'd have a nomination form that would be provided for, this is a nomination to replace so-and-so.
So when the number of nominations does not exceed the number of openings, is there still an election? In other words, you still have to get a majority vote or 20%, or there's no election, meaning there's no ballot. I, as a member of the association, not nominated, I don't pick anything because we've got in this case, we've got exactly the number of nominees as there are openings.
I'm sorry, I lost track a little bit what you're saying, but in this instance, if the nominations do not exceed the open positions, there's no election, they just take their positions. So for instance, if there was 2 people nominated for the 1 year spots and 3 people who were nominated for the 3 year spots, it'd be done and everyone would be appointed to
But people weren't nominated for spots. They were just nominated to be on the board, and the board has determined every spot's a 2 year spot.
Yes.
Okay. All right.
That's how I read what happened.
Okay. So what was happening tomorrow? There's no election tomorrow. It's just terms kick in because terms expire today. So at the sound of midnight, Roy resigned. Mr. Carr, he's done at midnight tonight, unless he nominated himself to be back on the board. And you said there weren't more nominations than openings. So then Carr would have another term, but otherwise Carr's done, has to hand in his director badge.
Yeah, I believe there's other rules in the bylaws that don't allow someone to go for 2 terms in a row on the board, but beyond them.
Okay.
I think he could be on a committee potentially, but beyond that, yeah, that's right. He's done tonight.
Got it. Okay. All right.
And so that,
They have to wait until the election.
okay, gotcha. Understand. Okay. Mr. Bhaumik was just telling me regarding the committees, the committee positions would be filled after the board of directors is placed for the new term.
But I've not read anything about challenges to committees or anything. This is, how did we come up with the terms of the open seats?
Yes, that's right. And that is really all the primary thing today is to say the election that just occurred, or the election process, we'll say, is what just occurred, the nomination, and it was faulty, that it should be redone in a way that allows all the members to, have, to be able to exercise all their essential rights in the election process, and also all the members to have an opportunity to be nominated for positions that they might otherwise have taken. And then also, that's really what we're looking at. We have a claim in there about an issue with the appointment of somebody to fill a director role temporarily. We're not pursuing that at this point. But we do also have a claim for attorney's fees. And the reason we believe we have a basis for attorney's fees in this case is because this issue was brought to the attention of the board after at least the February 1st call for nominations by Dr. Bhaumik, by others. And the response was, we're just doing it the way we're doing it.
Okay, and there's no magic bylaw that says the board can never have to pay attorney's fees. You can sue the board, you can't sue a director. Got it. Okay.
Guess we could have done a derivative action, but I don't think that was the right thing.
No. Okay. I think I understand that. Tell me how you'd like to proceed in term, and I don't know if you have had a chance to talk with Mr. Ratchick. I'm fine taking evidence. We're working off the same documents. And so I don't know that we need to pivot in that way unless there are disputes of fact that the two of you think I need to resolve in figuring out whether there is relief to be afforded. In other words, an order saying, nope, not so fast. You can't seat 5 two-year term directors now because that's inconsistent with the rules. I mean, that's sort of in essence what maintaining the status quo, and the ultimate relief would be 2 of the 5 can't be for 2 years. They need to be for 1 year. But even deeper would be your client's request that perhaps the nomination process needs to happen again. It could happen quickly, where you are nominating yourself or a friend for a 2-year or a 1-year spot. Because there might be that novice who says, I'll try it for a year. I don't want to commit to 2. But if I knew there was a 1-year term, I might raise my hand. And that might have caused there to be 7 people who nominated themselves or nominated people. And then it becomes contested and there's an election. But clearly the board knows how to work through that.
And there's one other aspect I just want to mention. If the election proceeds with appointing 5 people to full 2-year terms now, then there would only be 2 full-year terms to fulfill coming up in the next election next year. And what that does is it skews the staggered election process on the board. What you have right now is 4 elected 1 year, 3 elected another. And if you elect 5 to the board now, what will happen is you'll have 5 elected now and 2 next year. And if over the next year the membership doesn't like what's happening with the organization, and they would only have the option of replacing 2 instead of 3 next year. And the purpose of that is to be able to affect change. And to affect change, you need more people on the board that you want to elect. So part of that is it helps the balance of power.
You'd have every other year an inability to shift the majority if that was the will of the membership.
Yes.
Okay.
Okay.
Got it. So I don't know how you'd like to proceed. Mr. Ratchick has stood up a couple times when I've asked that, and I'm open to doing this. We have until 11:30, so we've got another hour.
Yeah, I was just going to propose, that was sort of an opening, and if I could sort of make an opening as well.
Sure.
Because I think there were a few misconceptions or errors in the recitation that if I at least present them, it might help clarify what we understand to be some of the facts. That may make the presentation of any evidence better.
Let's do that.
Okay.
Your turn.
Wonderful. Thank you.
And something's been beeping. I don't know.
Yeah, I'm trying to get my watch. I've got a new watch and I don't know how to use it. Sorry about that. There we go. I just silenced it.
I'll just come up here. And if it helps, Your Honor, and we did not submit this previously, but let me just give this to Casey. We put this together. It's not evidence per se, but if I can give it to you, I'll just walk through it with the court.
Sure.
Right.
Thank you. Oh. Do you have one more?
I've got 4 more.
Great. If you give one to Ms. Niles, that would be great.
1, 2. And I'll also be looking a little bit at the bylaws, if it will help you to look at or pull up sections 5.6, 5.5, 6, and 7. And I have physical if you want copies of those as well. I know that Mr. Libby included them in the petition and what he submitted, but if you want them, I'm happy to give those to you. Otherwise, I can just reference them.
Okay, let's get going.
Okay. There's a little bit of a difference. Most of the facts are fairly accurate. But what is wrong is that when this process started, let's say on December 31st of 2024, there were 7 directors. There's no dispute there. There was a resignation on January 1st that was accepted by the board on January 5th, and that was Director Paul.
Your client's concerned about something.
Okay, I'm sorry, yes. They say it was January 1st. It was actually January 5th when it took place. Either way, it brought the board composition down to 6 people.
All right, and Mr. Paul he had a whole nother year left. His term was a March 26 expiration.
That is correct.
Okay.
And so rather than fill that vacancy, they operated with only 6 directors.
Which they can. That's
Which
still more
they
than
have
5.
the right to do, exactly. So if you look under provision 5.6 of the bylaws, the term, it says, I'm sorry, under 5.7, a director elected or appointed to fill a vacancy due to resignation or removal from office shall be only for the unexpired term of his or her predecessor in office. They didn't fill the vacancy.
Well, they didn't then, but it's still a vacancy.
It became a new seat starting tomorrow.
That's your interpretation.
That was the board's interpretation.
Okay.
Right? So when they did this, they understood that because they weren't filling a vacancy and because they weren't appointing anybody.
What in the bylaws or common sense and reason makes someone think that it becomes not a vacancy before March 31st, 2026?
You mean today? You mean next year?
I do,
Yeah.
because Mr. Paul's term was through March 31st, 2026.
Right.
And it's vacant today, it's vacant tomorrow, it's vacant next month. You can fill it, but you're filling a vacancy because that term goes through the end of March of 2026. What's magical about today as to that term?
Because they believe the board, their understanding was first, there is no requirement for staggering the terms. Right?
Okay.
I heard Mr. Libby talk about that.
That sounds like a policy reason as opposed to a bylaw reason. Hey, you want to stagger terms for policy reasons. I hear you.
Right, but it's not in the bylaws and it's not a requirement.
Mm-hmm.
So there was no notion under the rules of the association that says we're supposed to do this to preserve staggered terms. So what they understood was if we're not filling that vacancy is not just for the unexpired term.
Where is that in the bylaws?
Right there in 5.7, it says a director elected or appointed to fill a vacancy due to resignation or removal shall only be for the unexpired term.
Right.
So if they don't do it, by silence, they understood a new director position with a 2-year term was going to come available as of tomorrow.
Right. Where is that theory that the last year of Director Paul's term becomes a nothingness and a new, fresh, full 2-year term is born because of What? I don't see that language in there. It's a 2-year term and it is a vacancy because of resignation. And there's nothing in here that says those 2 years can be truncated because we hit April 1st.
Well, I think what the board's position was, because we're not going to fill it.
But they're filling it. There's a new body. Let's assume there's 7 seats at the table.
Correct.
There were only 6 people sitting around that table as of January 6th of this year.
Correct.
Okay.
Yes, as of the 5th.
January
Correct.
6th, there are only 6 people at the table.
Correct.
Tomorrow, there are going to be 7 people at the table. And that chair that says Paul has someone else sitting in it.
No, that's just it, Your Honor. As of the next day, there's not going to be anybody filling it. There's not going to be anybody filling it until tomorrow.
Right, the next day, tomorrow. So
Oh, I'm
April
sorry.
1,
You said the next day. I thought you meant.
assume the board meets every day. And if I were to walk into the boardroom on January 6th, there's 6 people sitting there.
Correct.
There's an empty seat with a placard Paul there. Tomorrow, if I walk into that boardroom, there will be 7 people sitting around. Someone will have taken Mr. Paul's seat.
He will have taken that seat, but not pursuant to his unexpired term.
Except his term doesn't expire until end of March next year.
What we're saying, and it's a little bit circular, is no, they didn't fill the vacancy. They elected a new they elected a new director, and he's not constrained because he's not filling the unexpired term.
Okay.
Because it was a brand new election.
I understand your words. I don't see authority for that in the bylaws, but you're going to convince me maybe during the course of this morning. So,
Okay.
But I understand the board's perspective.
Yes.
That they think for some reason, if you resign early enough, the remainder of your term can be vacated and a new directorship is born. Not meaning they added an 8th. Correct. Again, if I'm pretending that Mr. Paul was number 7, that number 7, even though it was his until the end of March next year, by everything I read in here, if he leaves before his first year is up, presumably if he left on May 1 of this year, if there was a special election to fill it, there'd be no claim that that's a brand new 2 years. It would be, you're filling the remaining 11 months.
But again, the one thing that we keep missing is that's assuming that they choose to fill it, because they have the right not to fill it so long as there's at least 5 people.
Good, I got it. Okay.
Right? So again, the board's perspective is we can operate until we fall below 5. We don't need to fill vacancies until we get below 5. So that really was the position taken with regard to both spots that came due. You have Mr. Paul's resignation. And then what's important is after Mr. Paul's resignation, and you have 6 people on the board, on February 1st, the board sent out its first set of nominations, right, seeking 4 nominations, right? That went out on February 1st, 2025 at 2:11 p.m. And that is in Exhibit D to their petition. And it's referenced in paragraph 18 of their petition. So they sent out the nominations seeking 4 spots. Later that day, you had another resignation, and that was Mr. Dar resigned. And that was at 7:15 p.m. on February 1st.
And he is another term that runs through end of March next year.
Correct.
But the board is viewing that as not filling a vacancy, but putting in a new, same logic.
Same logic
It flows.
there, because now they're down to 5 people, they can still operate. All right. And by the way, in paragraph 18, they've alleged that Mr. Dar resigned in protest over this, but actually, and we have his resignation letter, it says nothing about that. It's just not there. Obviously, their allegation that it was in protest is, for now, hearsay, and we would challenge that.
But what paragraph 18 says is that Mr. Dar was protesting this notion that Mr. Paul's term would basically, we wouldn't worry about it anymore, and the person
for me to point nomination form seeking 4 spots went out before, so that at the time that the nomination form went out, there were only 4 positions up for election.
That's why there was a second one sent out in February 13th.
Exactly.
Hey, there's been a change. We actually are going to be filling 5 positions.
Exactly, Your Honor. And so that is Exhibit E to the petition and referenced in paragraph 19 of the petition. And so they sent out that new nomination form for 5 positions, just as was in the first case. The deadline to submit nominations was February 17th. Right? And yes, all for 2-year terms based on the same theory that I explained earlier. At this point, there were 5 directors. They were still able to operate. The nomination form that went out on the 13th went out at 1:14 a.m.
Someone's working late at night for the association.
Yes, indeed. And so, and that timing is important also, because when that nomination form for 5 people went out, the board was still properly constituted. Later, at 10:27 a.m., Ms. Roy submitted a resignation, and she also explained why she was doing it. She had personal reasons for having to leave the board.
Unrelated to frustration about 1-year versus 2-year terms.
Never mentioned it. And again, we're happy to show you the letters of resignation for both of them. That was accepted by the board on February 17th. Ms. Roy's resignation was accepted on the 17th. Her term was set to expire today, right? So they only had at that point roughly 40 days to deal with. And rather than have a special election for that 40-day period, if you look at Section 5.7, it talks about appointments as well as special elections. The board understood that they could appoint that director. And so they appointed Mr. Roy, unrelated, but they appointed Mr. Roy simply to serve out the 40 days. He was not, so his term ends today. And that does not carry over into tomorrow and for 2 years. So they understood that they could appoint that so that they are properly constituted again, up to 5 people. And then
So Ms. Roy's spot was already one of the 5 nominations because her term was expiring today anyway. That didn't require a panicked 3rd email saying, now we need 6.
No, it doesn't.
Fortunately, hers was a term ending today.
It was already contemplated that that had to be filled. So
Okay.
it was part of the 5. Yes, sir. Right? And so now the board is again fully constituted with 5 people. The only thing it did, remember, it sent out the nominations. So the only thing it did was count the nomination forms. And as Mr. Libby properly said, only 5 nominations came in. No, Mr. Carr was not running again It's new people. And by the way, you can't nominate yourself.
Okay.
All right. And we have the nomination forms if you want to see them. So and it requires that you submit a paper copy and that you also then email in by the 17th a copy of your nomination form. So there were 5 nominations made and 5 nominations accordingly accepted. So you didn't have to have, whether we call it runoffs or, contested elections for the seats. 5 were elected. What's really notable here is that the petitioner never tried to nominate, never got anybody to nominate him. And by the way, you must, as the nomination form provides, you have to accept the nomination. If somebody nominates you and you don't accept, it's not taken by as part of the process.
You can't be conscripted onto the board.
That's the word I couldn't remember. Thank you.
Why is it remarkable that Mr. Bhaumik didn't seek to get nominated? I mean, maybe he doesn't want to be on the board, but he wants the board to be properly composed, or more importantly, that your terms are your terms and we don't shave a year off the term of a seat.
I'm trying to understand what his irreparable injury is here. I mean, I understand, and unfortunately, too many people have sat, at least in this courthouse, if not this courtroom, and said, the election was stolen from me. Okay, there's no injunctive relief to address any harm that he has suffered. All right, and let's be very clear, he sued personally in his personal capacity. He's not suing on behalf of anybody else. He's not suing on behalf of members. He's not suing the board. He sued the association, but this is, how was he aggrieved? And, he didn't want to be on the board. He also didn't challenge it until he wrote a letter, or his lawyer wrote a letter on February 28th, right? After everything was done. And we do admit, and there's a whole backstory to why that letter wasn't responded to before they filed, and that's because Mr. Libby had previously, I guess, been engaged to write a letter regarding something else that the board tried to respond to like 3 times and then got no response back. And so the board frankly thought, we're not sure that this is real, or they're getting spoofed, or whatever it is. So over the course of a week, plus there had been a death in the community that they were dealing with. It was Mrs. Roy, right?
No. Can I speak?
If it's just about this one.
Yeah, this one.
Okay.
Yes. Basically, one of our director's husband passed away.
Okay.
Yeah.
So we had to deal with it.
Yeah. So over the course of that 7 days or something, they didn't respond to the letter. And then on the 7th or 8th day, the lawsuit got filed. So that is the process. We think that we understand Your Honor's questions about whether or not it should have been for 1 year versus 2. You know why the board did what it did, and we think that the language is there because the only restriction on whether you fill the remaining term is if there's a vacancy or an appointment. And since there was neither of those, then we think maybe the silence on that issue actually supports the decision that they made.
Okay.
Then when it comes to the issue of whether or not there is, an injunction should issue, because that's all that we're here for right now. The bylaws do not require that you fill a vacancy, so long as there's 5 people. The bylaws do not require that the board of directors be comprised of directors filling any staggered term, despite the allegation of that in paragraph 28 of the petition.
how did that come to pass? Is there in the bylaws, hey, in our first session, 4 of us will have a 2-year term and 3 of us will have a 1-year term? How did it become staggered if it wasn't built into the bylaws to begin with?
I am not hesitating because I'm trying not to answer it. I don't actually know the answer, but what I do know is that my client and other directors consulted with prior members about this to figure out, are we doing the right thing? And rather than me put the words in his mouth, he'll testify if the court requires it or if it would help the court. But they did, and they were told, no, this is appropriate. And they were told that by prior directors.
Okay.
Based on the prior director's reading of the bylaws and their understanding of the intent of the bylaws. Then with regard to injunctive relief, I don't think that this plaintiff or this petitioner has standing to assert anything other than what he's done on his own personal behalf. And then irreparable injury. That's one of the things, cornerstones of suing for an injunction. He does not have the right to speak for any other members. If any other members had a problem, they could join this suit. You'll see a whole bunch of people who are, listening in on the Zoom right now. And I received a copy of a petition signed by 42 members at a meeting held yesterday.
Hold on for a
Unless
second.
this is going to be introduced as evidence, I think we're going into territory.
Right. Let's not get into
Okay.
hearsay like that.
Understood.
So you were talking about
very
irreparable injury.
Yeah. So there is no harm to the plaintiff personally and individually. He never sought to be nominated, never was nominated. He hasn't been deprived of a seat on the board. He's also not been adversely impacted because the people who were nominated accepted it. They were unopposed, so it's not as though anybody was left off. And everything that has been presented so far is speculation as to what some other member might do with regard to change nominations. They want a new election, at least for the 2 seats, because they think it might change people's perception, but they haven't introduced, and I don't know that they will introduce anything other than speculation as to what would happen. And speculation is not going to support an injunction.
Well, don't they also want it fixed that way because they say the bylaws, there's a policy reason for it. There is, maybe people wanted it to be different, so the speculation, but there's also a reading of the bylaws on their face that says this wasn't done the right way. I know you disagree with that. You told me, and so I'm not taking sides right now. But at the fundament of the complaint is, here's what the bylaws are that govern us, and it didn't go that way. And then you can layer onto it, and it should for policy reasons. Maybe it should because that would allow greater expression for voters or more choice or this or that. Right. And those do start to get out into the realm of maybes. But why is it not sufficient to say the bylaws say you can't do this? They did it. I'm harmed because you didn't follow the bylaws.
Well, I understand what you're saying. If that is the case, and again, we disagree with that interpretation, but if that's the case, then you'd be attacking 2 spots on the board. You're not attacking 5.
Right. Well, it's the remedy. We may need to discuss what the remedy would be like. In one way, you're exactly correct. It's 2 spots. But in the other, it's how do we know? Unless 2 people raise their hand saying, I'm fine for just 2 years. For just 1 year. And there are lots of ways to address it. If I decide a remedy is even necessary, The most extreme would be there needs to be yet another nomination email sent out saying, nominate someone, nominate them for one of the 3 2-year terms or one of the 2 1-year terms. Specify that. I'm nominating McBurney for one of the 1 year. I don't know how much I trust him, so just 1 year, not a full 2 years. That would be one way to do it. That is more disruptive than the people have spoken and 5 people were nominated and we can draw lots or
You've got 2 people who are willing to raise their hand if we ever got there.
Okay.
All right. But I think the whole thing is disruptive. When you talk about policy, public policy, the members have spoken, right? They nominated for this. And want this, and if it's going to be a question as to what serves the public interest, I don't think throwing the board into chaos serves the public interest. Nor do I think requiring 5 new nominations, which would leave the board with less than
Right.
with 3 directors or 2 directors means that now all of a sudden we have an inoperative board. Who's going to run the election? Who's going to do anything? You just don't have that. And so when you look at preserving the status quo to, serve the public interest, that ain't it. So,
Okay.
all right. And we're happy to take any questions or put witnesses on or however you want to handle it.
I'm looking at the notices that went out. So Exhibit D and then E.
Yes, sir.
What in those would have put me as a member on notice that these are for 2-year terms or 1-year terms, or I guess it says routine biennial appointment. And then Exhibit E. So if I had received Exhibit D, which was the February 1, if we go by your timeline, this happened just before Mr. Dar resigned or before. There's excitement for call of nominations for the board of directors, 4 positions open. And it says, hey, if you want to know how this works, look at the bylaws. And then it says there are 3 open positions for routine biennial appointment. That says to me 2 years. Additionally, there's 1 open position due to the resignation of Mr. I think it was supposed to be Paul. It says Pal here, but we're talking about the same person. And it doesn't say that's for 2 years or 1 year. How am I to have discerned that open position was for a full 2 years versus 1?
The nomination form itself says it.
Okay, so there was a link that you could click on and then that form says it.
Yes, and
Okay.
if you'd like to see a sample of it, I actually have all 5 of the nomination forms.
The form meaning
The
what
ones that
someone
were submitted.
filled out.
Yeah.
Okay.
Just if you're curious to see what it says.
Nomination for it, part of the petition.
It's in the petition?
Did you include these nomination forms?
Yeah, and up at the top, it's,
For 2 years?
yeah,
Yeah, okay.
that's what, yeah, I think it's part of the,
And it's your exhibit, what?
give me one moment. It's my exhibit.
Oh, I have one. Nomination form. It's attached to your letter.
Yes. And
Your letter is Exhibit G and it's an exhibit there.
it's the first paragraph under the title nomination form for Baga Board of Directors. You can see where it specifies.
Yeah, for 2 years pending on. Okay.
And that's the only form that was linked to in this email.
Got it. Okay. Well, and that's exactly what you said, is that it said 2 years. Okay.
Correct.
All right. Thank you.
Thank you.
So we sort of had openings and closings here. It's been very helpful to set the scene, but there's also, it's helpful to also have some argumentation. Mr. Libby, why don't you tell me what you want to do with the remaining kind of half hour we have?
Your Honor, we have, one, email we can put on. We can actually put two emails on that would just show that there was communications between Dr. Bhaumik, and the email is a chain, so his is one of many, so it includes others, but they would be hearsay because we don't have the declarants here, but also including an email. This email address of board of directors would be Mr. Carr, and that is Dr. Bhaumik brings the attention of this issue to the board, and the board's response saying, we're just going to do live. We're bringing it to the people is, I think, what the response is. I'm glad to put that on the record. And then there's a different email that's much longer, and this is a long email among, I think it's every single member of the board was listed on this email, but there's only one email that's pertinent in it. But it's, again, Dr. Bhaumik bringing the attention.
Every member of the board or every member of the organization? That's a long.
I mean every member of the organization.
Okay, got it.
Yeah, I think that's what it is. And I don't know how this got started, but Dr. Bhaumik does state in there one of his complaints is, and it's basically the same thing as his other complaint, is that they're doing the process wrong. And this is, both of these are dated February 4th. So this is 14 days, 2 full weeks before the actual announcement of the nominees, and 9 days before the follow-up email saying there's 5 members that are going to be elected. And I'll also note that in this February 1st email on the second page you were just referring to, I think it's Exhibit D, on the second page, note to open position, it says there are currently 3 open positions available for the routine biennial appointment of directors to the board. Additionally, there is 1 open position due to the resignation of Mr. Paul from the board of directors effective January 5th. They're specifically citing his resignation in this as a reason why there's a 4th position to be filled.
Right.
But they're just saying, they just argued that, no, it's just, that's not really, it doesn't matter that he resigned. The board can just choose to pick a 2-year term anyway.
Well, it matters that he resigned because that created an open seat.
I mean,
but I understand it. And I think the boss says this is how the directors have interpreted it. And apparently they consulted past directors. And so I get where they're coming from. I don't know that that's what the bylaws actually say. I don't have an issue with you tendering the 2 emails, but one of those decks you picked up looked like it was about 20 pages. And if it's a back and forth with lots of members, that part we don't need to get into unless Mr. Ratchick may not object because it may set forth the very reasoned view of members who think that this is much ado about nothing. We just want to be able to have a say as to who's on our board. We don't care how long their terms are.
I'll say, we can probably put aside this big one. This is more of a soap opera.
Okay.
It's literally titled The Great Baga Saga, starring you.
Okay. That's too bad. That would be interesting to read, but.
I'd be interested to read it too. I haven't seen it.
All right. Well,
It's the same date, the same time range that was written by Dr. Bhaumik that I would like to tender in evidence.
and this is the one that was addressed to, the name of the email address is just chairman of the board. And your assumption is that that is Mr. Carr.
Yeah, I understand that to be the case. The final email in the chain is from someone named Amit Potter, but it's a chain that's sent to multiple people. It's not the entire board, I mean, the membership, but it's to certain people in the membership. And it's directed to Baga, BOD chairperson. The email address is bodchair@baga.net. That's the email address that's on the website that's under Mr. Carr's name. So we assume it's him. And there is one specific entry on the second page where Dr. Bhaumik writes to the BOD chairperson email address, and that email address responds. So if I can go ahead and have him go ahead and authenticate this email, unless you want to stipulate to authentication.
Mr. Ratchick, I know there are a few exhibits here, but if you've had a chance to look at it or you and your client can look at it, we don't need to just call Dr. Bhaumik up just to authenticate it if there are no issues.
Yeah. Is he gonna get those? Right. Yeah, I mean, Mr. Carl certainly be willing to address what he wrote there, and it simply talks about they're defending that appointment of the fifth director.
Okay,
And that's all that's referenced in there.
okay. Do you have any objection, Mr. Ratchick, to having this made part of the record?
Just those first 2 pages or everything?
Just one moment, I'm sorry. Okay. I guess. Yeah, as far as the rest of those goes, I mean, I would just say they provide the context for Mr. Baumik's email, but as far as those goes, if he just wants to do the first 2 pages, that's fine.
Okay,
I can just take off these. Okay.
And if it helps for the record, this is part of, I guess, what you called exhibit 6 to the submission that he sent last week.
let me pull that up.
By Potter, yes.
So we would just be looking at the first 2 pages.
Yes.
Got it. Okay. You're not going to try to admit the Dragon King speaks?
No, that one, I just had it there just in case some context made it relevant, but
Okay.
that has not happened today.
All right, so we'll admit petitioner's exhibit 6, pages 1 and 2. So talk to me about the injury, irreparable harm, how I ought to evaluate that. I think Mr. Ratchick appropriately put that front and center. What's your view on that, Mr. Libby?
My client's harm is, for him specifically, would be the same harm each member would get, is that he was given and presented with an election process that did not follow the bylaws. As a member of VAGA, he was entitled to an election process that follows the bylaws. The membership, actually, I think recently, and he can testify to this, voted on an amendment to the bylaws to allow for online election process, I believe. And so that was an opportunity for them to amend the bylaws then. Whatever the case is, at the end of the day, this is their constitution. This is what they go by. It does not matter that the members, even if it's the majority of the members or whoever, went through with this process and elected 5 two-year terms to the board if the bylaws don't allow it. Because the bylaws are what is the foundation of this organization. And if you start to say, well, it doesn't really matter that we didn't follow the bylaws, well, that just starts a process, the slippery slope argument of, okay, well, the next time what's not going to matter in the bylaws? It does not matter that if every single person in the membership, but Dr. Bhaumik disagreed with this. The fact is the bylaws govern the organization, not the board of directors is there to enforce the bylaws. And this becomes what it sounds like is an organization that is run by the ultimate law is whatever the board decides, regardless of what the bylaws decide. And that's the argument here. Dr. Bhaumik was denied his ability to be able to pick 2 one-year terms for board of directors and only 3 two-year terms. And he was denied the opportunity to identify who's going to be running for what. For instance, it would be similar to when, I guess.
What's the harm if as a result of these proceedings, the board is directed to designate 2 of them as 1-year term and 3 of them as 2-year term.
Of the 5 directors that were nominated?
Correct. Because there was no vote. We talk about this election process, and
Yes.
it's a slightly misleading. It's correct. There was an election process that resulted in no election.
Yes.
Because there were 5 candidates for 5 slots.
Yes.
And I know one form of relief you've suggested would be to discard the 5. That sounds a little rough, but to say those aren't necessarily the 5. We have to send out a 3rd nomination email saying you need to nominate someone for either a 2-year slot or a 1-year slot. So when you pick McBurney, let us know whether it's for a 2 or a 1. So that then if you're going to create this odd situation where what if only 5 people are nominated again, but 3 of them are for 1-year spots and 2 of them are for 2-year spots? Those 2 for the 2-year spots are on the board. There's actually an empty, unfilled seat. And then the 3 become an election. Choose 2, and you're choosing 2 of those 3 for the 1-year spot. I make it sound like that's a huge headache. It's not a huge headache, but it just is that you're not guaranteed that the 5, if those same 5 were nominated again, you don't necessarily fill all 5 seats.
Yeah, and under the bylaws, that would be okay, because you don't have to have 7, you only have to have 5.
Right.
And if for whatever reason, they could run an election process and nobody nominates themselves, and then you'd have, for instance, in this case, 3 people, or I think there's only going to be 2 directors as of tomorrow, then you have 2 directors on a board, and if no one nominated themselves, you have the scenario of what do we do? There's a process to go through that. The important aspect that Dr. Bhaumik is asking this court to enforce is the process is what matters. And that the process, how you run the process could lead to different results and different outcomes. And it's important to make that distinction because it's the same reason it'd be important, in 2020 when I think it was John Ossoff and Ms. Leffler were running, and then I think David Perdue and Warnock were running. If we just said, we're just going to put all these 4 people up there and we're just going to choose who you want to be senators and we'll figure out who's going to be 2-year and who's going to fulfill the, I think Perdue's remaining, tenure or whatever was happening at that point, whoever it was, I can't remember, but, or the special election. We're just going to decide that afterward. That would be denying to people the choice of who they want to be in those positions. And that's what we're talking about here. It goes to the fact there's a reason why the process is staggered.
Does there need to be a reason? I mean, you have speculated as to one, and Mr. Ratchick has pushed back a bit saying, we don't even know if that's the reason. And past directors seem to have said, you can kind of ignore that rule anyway. But do I need to find a reason? If it's in the bylaws that you can not ignore the remainder of a term and extinguish it, you would be filling the remainder of, for example, Mr. Paul's term.
Mm-hmm. Do you need a reason to fill it?
No. Does there need to be a reason for why the bylaws say that? If I agree with you that, because you have several times said, hey, there's a good reason why it should work this way.
Oh, I understand what you're saying. And yes, there doesn't need to be a reason. The bylaws are clear. It's just that sometimes it's helpful to understand, well, why would the bylaws say that? But no, the letter of the law, it's that provision in the bylaw 5.7, if there weren't the expectation that an election would fill unfulfilled seats after unfulfilled terms after somebody resigns, then there's no point in that provision. It's just that every time someone resigns, you can just hold a new 2-year election. It would have no teeth. So for that reason, we think that certainly it's the election process is what is important. Dr. Bhaumik was actually chair of the board from 2022 to 2023. Yes.
Also 16, 17.
So he has experience in this, and he went through an amendment process with the Constitution, with the bylaws. So this isn't something he's unfamiliar with, and he has served the board. But his concern is, when I was doing it, when the people in the past have done it, and how we go forward is the bylaws have to be satisfied because that's just it. It's just obvious.
Okay. Mr. Ratchick, we've sort of been free form in how we do this. If there is evidence you think I ought to receive beyond what you've shared with me, I'm happy to give you an opportunity to do that. And you're also welcome to make some argument if there's more argument you want to make.
What is it? The vacancy one, the interpretation. Is it different? The nomination form was cut in many other people. We did not fill the vacancy previously. The nominations. My client would like the opportunity to explain to you what their interpretation was and why they acted the way they did. I can either swear him in or he can simply tell you. If you'll hear it.
No, I'm happy to hear it. And I don't know that you need to be sworn in. Mr. Libby, do you mind if Mr. Carr explains the way he interpreted it, or do you want him on the stand? Do it however you want.
I don't necessarily need for him to come to the stand, but I suppose it might make sense just to have him under oath.
Okay.
Is that right?
Why don't we do that? And we get you sworn in, and then we'll hear from you.
You want me to swear him in or do you want?
No, we got the official swearer in coming right here. All right, Mr. Carr, if you'd stand and raise your right hand, please, and face that gentleman.
You swear a firm testimony you're about to give is not to speak the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, and Mr. Carr, you can stay right where you are. Just make sure the microphone is, and you're welcome to stay seated. Just that microphone, the stock moves, so just move the microphone towards you. There we go. Okay.
Thank you, Ahmed. Good morning. So for when these positions opened up, starting with Mr. Shantanu Paul, who resigned because of his some personal issues, nothing to do with the board. Then we started looking into the filers, and we actually consulted previous chairpersons because we also want to make sure we do it right. Now, what we found out is that even when Mr. Bhaumik, respected Mr. Bhaumik, was the chairperson in 2017, and even when he was the chairperson in 2023, and I was the secretary actually of that board working with him in 2023, 1 year. So we worked together on the Constitution. So now the explanation that we thought the board, it is not my personal opinions. It is.
No, I want to be clear, Mr. Carr. I'm not viewing you as this scheming mastermind trying to take over the world, first BAGA and then MAGA or wherever you're going. So I don't worry about that at all. I think you were doing your best with your colleagues to apply the bylaws.
Yes. So we consulted 3 previous chairpersons. Now, I wanted to consult with Mr. Bhaumik also. But however, going back to last year, there were some, after he left the board, so I had some questions. I wanted to have some guidance from Mr. Bhaumik. One was about some food, one was about some submission of the form. So I had called him at least twice. He has never returned my call. So I thought probably he's not happy with me for some reason, and I didn't want to bother him. So I went back to 3 very, very senior individuals who have served in the board many times. And in fact, one of them, if you see one of the exhibits, she is actually was one of the founding directors of this 501c3, Mrs. Nita Bose. So we had a very detailed discussion that what is the intent of the definition of the word vacancy. So we went back to several years in the past, and what we saw, a tendency or the trend, whatever you call, and I was also part of the board in 2000. I was in the executive committee twice. I was in the board once. This is my second term. Not that I wanted to get in, but people convinced me. So then we had a very detailed discussion. The definition of the vacancy, the way we understood is that that is applicable only when it becomes below 5. Because we went back to several resignations in the past, several. In fact, under Mr. Bhaumik in 2017, 3 female directors resigned on the same day. And I'm not going into the reason because it is not the purpose of this. But then only one was filled in. And the reason is that because he fell below 5. So he considered after falling below 5 is the vacancy. So he filled in, quote unquote, the vacancy for 1. He did not fill in the other 2. It happened again under his chairmanship last year, where we had again resignations for different reasons. I'm not going there. He did not open it up to fill in the vacancy. So that gave the impression to the board as well as to the members and to the other directors, other chairpersons and presidents that I spoke to, that yes, it is true, the vacancy comes into play based on if you really make a deep dive into the 5.6 and 5.7, yes, probably it could have been written better, but this is what it is. And nobody said, even going back to the founding member of 501c3, actually it was only 5. Then at some point in time, some chairperson decided to actually add 2 more directors. So it was never a policy of 4-3. The reason it became 4-3 because of some of the resignations, it became 4-3 somehow. And sometimes down the line, it may be 5-2, sometimes 6-1. So there is no restrictions in the Constitution that says it has to be 4-3. No. And then the vacancy definition understood that you fill in the vacancy, quote unquote, when it goes below 5, because that is the precedence we have seen, either through special election or through special appointment, if it is very close to the election date. And believe me, Your Honor, we have debated it day in, day out before we took the decision, because what our position was, to think about this, a section talks about it should be 1 year. A section talks about it should be 2 years. There is a division. So we went by the feedback that we got mostly, as well as the majority of the board members. They said, yeah, it makes sense because the board that comes in, that it goes into the quote unquote normal election process. Normal election process is defined is understood so far over the years that it is for 2 years, because Mr. Bhaumik has appointed in 2017 one individual through special election. The reason that we have analyzed this before taking the decision is that the individual resigned, 3 individuals resigned on 1st of April. And at that point in time, the election was down the line, way down the line, right? So now you cannot wait for the normal election. You have to have a special election. And when you fill in the vacancy, your remainder of the term is applicable. In this case, Your Honor, holding my hand to my heart, absolutely, we went back and forth. Several debates happened. There was no intention to harm anybody.
Okay.
And one more thing I have to say, Your Honor, is that if Mr. Bhaumik, I was just one phone call away, one email directly to board, directly. The email that he has sent, if you see the exhibit 1, it was written to one of the individuals, Arudhar, who resigned because of the difference of opinion with the majority of the board. Now, one simple email, and we received many emails over the week. We sort it out, we go back and forth. But when we see, we are not, Your Honor, we do not understand laws and regulations that much. So when we see an email thread has a lawsuit threat, we are so scared that we say, one thing, we cannot reply, because if we reply, and then there'll be a lawsuit. So that email trail that he has shared down the line, if you see deep down for something else, it has some, and it has, and if I may say that couple of times, and I'm not saying it's right or wrong, he has threatened, and I have emailed the community about the what is it called? The lawsuit.
Okay, and here we are. So there was a lawsuit. I want to be very clear, Mr. Carr. I don't think any of this is suggesting that there was evil intent or bad intent. It's a question. It's very, in some ways, it's very dry, and I don't want to use the word boring because it's very important. But it's, what do these words mean? And it's not about swindling or, oh my gosh, under the Carr regime, all this money went away from the community service fund. That's not why we're here. But people feel very strongly about how they get to be involved with choosing the directors. I get that. They're passionate about it. And there is a reasonable disagreement, and lawyers have been brought in as to how you read 5.6 and 5.7. And that's all I'm going to do is say, well, I guess I get to break the tie. And here's what they mean. And then going forward, you'll have that guidance. It's like, hey, you know what? The judge said we do it this way. And it's either okay the way it was, or nope, if someone resigns early before her 2-year term is up, whoever comes into that spot, whether you call it a vacancy or you call it an open seat or you call it a ham sandwich, you are filling all that remains. And it could be 40 days, like we had with Ms. Roy, or it could be a full year, which is what we've got with several of the members. And your organization is entitled to that clarity. And clients can disagree, which is why we're here. So I appreciate you sharing that. Mr. Libby, did you have any questions of Mr. Carr, or you've heard what he had to say?
I've heard what he had to say. I know we're at the time limit, Your Honor. I just wanted my client, he obviously had testimony about things that he did and would have an opportunity for rebuttal to what Mr. Carr had to say.
So if Dr. Bhaumik wants to speak for 5 minutes or less, I'll put him on the clock. I will listen to what he has to say. I also want him to know that I didn't hear Mr. Carr say anything that's really inconsistent with what we've been working through. And there may not have been the smoothest or friendliest of communications amongst members and members to the board. But that's, again, not what this is about. The bylaws say what they say. And if I conclude that they say you're filling the remainder of a term, then things have to work a little bit differently going forward. And if I adopt the position that Mr. Ratchik has advocated and Mr. Carr spoke to, then we move forward that way. But if it will help your client feel like he was heard as well, if he wants to be sworn in, I'm happy to hear from him for 5 minutes.
Okay, thank you, Your Honor.
All right. Another swearing in, please.
Sir, you will raise your right hand. You swear to affirm testimony about giving facts, the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat, on the lead.
All right, doctor, if you would, please.
Yes, Your Honor, I had the privilege to serve the board 3 times. One with one of the founder member that the defendant said is a Snita Bose, that she was the chairperson. Now I was there, and I was the lead of the Constitutional Committee, because 1999, when the first 501c3 form and with the Secretary of State was registered, she was there. But then the lot of evolution happened, the Constitution. So at that time I was in the board, I was in the Constitution. Then after that, 16, 17, I was the chairman. I had also helped amending lot of the Constitution several times. And also,
When you say constitution, I know there's articles of incorporation and there's bylaws. You're talking about the bylaws?
Bylaws.
Okay.
But, and in 23, I was again the chairperson. And again, I had amended a lot of the bylaws. And the defendant was the secretary at that time,
Okay, we can call him Mr. Carr.
Mr. Carr.
Okay.
So my whole purpose is to file this petition, is to have the integrity of this 501c3. If we don't follow the bylaws, a lot of evolution happened. A lot of other chairpersons didn't talk to me, didn't consult with me. And the spirit of the bylaws doesn't maintain, then the whole thing fall apart. You know that. So my whole petition purpose was to follow the bylaws. And when this first nomination paper was requested, February 1, at that time, several members, that 2 pages, exhibit 10 or whatever it is, and including me, even the some board member, one board member, Mr. What's her name? Mr. Roy, Mrs. Roy, she was also complained this process is wrong in that email.
And wrong meaning you, the board, are trying to turn what should be just a 1-year term into a 2-year term. Is that what you mean by wrong?
Yes.
Okay.
Our thing was have 2 nomination form, one for 2 years, whoever will be interested, another for 1 year. Let the people decide, whoever, proper election, but didn't go through. It's only one. But so we failed. And then many of the members, including me, didn't work. So again, another member resigned, and you know the whole sequence you heard about. I don't like to repeat and take time. And so the petition happened that, okay, please have a proper election. What's wrong with that? If anybody does not, any more other candidate doesn't think, the same candidate will happen. If it is other candidate, then it will be election. That's it. Okay? And if we do not like to open loopholes for many things, okay? Even the American federal government constitution has a lot of loopholes, right? You know that. So we are hearing every day. So our thing is that this is a charitable organization. Let us follow the rules. And that was the main purpose of all this request.
No, I appreciate that.
And another thing is that the controversy that after today, what will happen if the election, how the organization will run. But in the 5.7 say that even if the term finishes, until you cannot hand over your responsibility, you have to continue. So it is not that Mr. Kaur or the other board members has to go today. If there is no candidate or person, they can have a proper election, and if the members come, then hand over, then their term. It is clearly mentioned in 5.7. And another thing, appoint word, there is a word appoint in the 5.7. That word was included. The spirit was, if you see the eligibility of the candidates, okay, election committee also justifies the eligibility of the candidate, whether they follow certain requirements to become a board, okay? In the last section, in the 9.3, there is a condition. If after repeated request for the nomination, whatever things, 1 year or 2 years, if you do not get the right person, then the board with the majority vote can appoint. That's why that appoint word, okay, just to satisfy that things. So that is I like to say that our members get the opportunity to vote or to apply for the nomination with a proper election process. If we do not, then another issue of the bylaw will happen. Then this whole 5163 IRS,
Got it.
it
No,
will not work.
that's helpful to understand that there's that deeper concern that I suspect most of the members share,
Yeah.
that we don't, you, the organization, the association doesn't want to do things that would jeopardize the 501c3 status.
Exactly.
Okay.
And that was my whole purpose. I'm not getting any benefit out of it. But it may happen if the proper election process was there, maybe many of our, in the email chain, many of our people could apply. If they said, hey, this is Dr. Bhaumik, the process is wrong. We are not going to that.
Okay.
Okay?
Yes, sir.
Even I may include apply for myself.
Again.
Why not?
Okay, but I thought you can't
If it
nominate
is-
yourself.
if the duty-
That's on the record.
Yeah.
Yeah, everyone's listening, but they know that you may be willing to serve again.
So that's my only statement, that we need to have a proper process, not only for election, everything.
Yep.
What the bylaws say.
Fidelity to the bylaws, that's important. Okay. Well,
If it is not, if the board thinks it differently, let us amend that,
right.
okay? There is amending process.
Okay. Thank you.
Okay, thank you.
Your Honor, can I just have 15 seconds?
You sure can.
Okay. Take a look at section 5.1 of the bylaws also at your leisure. I would just submit to you that 5.1A and 5.1B basically put the ultimate authority in the hands of the board of directors for all the governance, management, et cetera, and also say that the board of directors shall set the policies as deemed necessary. To the extent that there's any ambiguity in the bylaws, it really does come down to the board to determine that. And so within the scheme of the bylaws, unless the court actually finds language that is preclusive of our interpretation, I think our interpretation actually, the court should yield towards the board's interpretation because 5.1 says it should. And then if you also just look at 512 at the end, if the membership deems what the board's doing wrong, they have the right to take action. So there really isn't any irreparable injury. The membership has the ability to challenge what the board is doing, and nobody's done that. And so therefore, when you look at balancing the harms and who's sitting in the right, etc., it's in the bylaws that if they want to attack the board's thinking, they have the right to do that. Thank you.
You're welcome. I'll look at those. I will note that 5.12 doesn't provide much of a remedy for someone who feels isolated by what the board is doing, and there happens to be a majority view in favor of what the board is doing. If the board is flouting the bylaws knowingly and intentionally, and enough people just don't care about that, then someone's a voice in the wilderness and they can't get redress through 512. But I hear you.
I understand what you're saying, and if they were flouting it, it would be one thing. If it's a reasonable interpretation, hopefully.
Well, that's where.
Within 5.1.
Exactly, and I will look at that. All right, Mr. Libby, as the movement, if you will, anything you want to say to wrap all this up?
No, Your Honor. Well, not say no. Of course, I want to say something. Your Honor, we just ask that you, again, coming into this really just does come down to what do the bylaws provide. And we think that section 5.7 is very clear that when you're electing full members to the board, all these members, and you've got 3 resignations, that in order that the bylaws just require that some of those nominations be to fulfill unfilled terms.
Got it.
Look at the letter of the law, and we think that that is the only reasonable interpretation, and that we think that Dr. Bhaumik should get his attorney's fees for having to bring this case to the court and defend the bylaws of the organization.
Okay, thank you. I will reach out to both sides if I have questions, need additional information, et cetera. Otherwise, I appreciate the urgency of this. I don't know that by April 1, there'll be clarity for everyone, but I also don't know that my remedies are limited to acting between now and I guess it's like 12 hours and 17 minutes. I think I've got a little more time than that, but that doesn't mean I'll go slowly. This is going to be a cloud hanging over what's going on with the organization anyway. And so it would be helpful to clear all this up.
Thank you, Your Honor.
Is there any, can we have an agreement? There's no injunction in effect until you rule. So the board can at least proceed with what it believes to be its status until an order is received.
Correct. I have not taken action on anything yet. We needed to have this session to give me enough information to formulate a plan. And until that plan is announced by way of entry of an order, then the status quo is what's happening right now.
Fair enough.
But that's why I appreciate the urgency of it, because it's not going to be real helpful if the board gets 2 months under its belt and I say, this isn't the board, there need to be a new round of nominations. The organization will persist and things will continue to happen, but it's disruptive. And so the sooner I can say, here's what I think needs to happen, the sooner then you can advise your clients to say, that judge is so crazy, we need to appeal this, which will prolong the uncertainty. Or, all right, I don't necessarily agree with what the judge did, but this is sufficient closure that we ought to accept his ruling and move forward in a manner that's consistent with it.
And just to reiterate, if the judge, if Your Honor decides that 2 people should only fill for 1 more year, there are 2 who are willing to do that.
I did not hear that the first time. I appreciate that.
Very.
All right. Thank you all, and please make sure you take care of the court reporter. I don't know who had the court reporter here, but you settle up what you need to settle up.
Thank you. All right, I'll forward the invoice to you. Thank you.
All right. You're